Good afternoon, everyone. We are still waiting on one fellow, but I think we should probably get started at least with introductions. As I mentioned in the reminders, if you all could turn on your cameras, Sarah intends this to be a pretty interactive session, and therefore she is not talking to a bunch of boxes. I think she prefers that. But anyway, welcome to programming for this month. Thank you all for coming. And there's Simone. Perfect. I'm going to let her in. Sorry, Sarah, I just muted you on accident when I was trying to let.
That's okay.
Okay.
I unmuted me.
Awesome. All right. That should be everyone now. Welcome. We'll start over.
Hello.
Welcome. All right. So today we are having our programming on client interviewing. And Sarah Taylor is an attorney in Carbondale for Barrett, Toomey, Broome, Hughes, and Hoke. And she also serves as the chair of our Rural Practice Initiative Committee, which administers the program that you are all participating in. So again, it's good to see everyone today, and I'm going to hand it over to Sarah. Let me know in the chat if you have any questions throughout the program or need anything from me, and I will be here, okay?
All right, thank you.
You're welcome.
Can everyone hear me okay? Yes, okay, good. Well, first of all, I want to say welcome. Thank you for being here for this program. I know you're required to be here, but I guess you could have watched it later recorded. It's much nicer to have you here in person. So I did want to take just a couple minutes because I have not actually really met any of you. So I'd like to just take a couple minutes if everybody can introduce themselves, just a brief introduction, kind of who you are and where you're working, and you know what town that is or what county that's in. That'd be really helpful. As Krista said, my name is Sarah Taylor, and I've been an attorney in private practice since 2004 with a law firm, Barrett, Toomey, Broome, Hughes, and Hoke in Carbondale. I did take a year off to work for the Public Interest Law Initiative, which is a nonprofit. So I did that for a while, for about a year. But other than that, my practice is very heavily client-based. I think I estimated at one point I've had like over 1,000 clients probably in various capacities, and most of them are individuals, although I do have, I represent the state of Illinois in some cases, and I do work for corporations from time to time. So kind of a variety of things. No criminal law experience other than law, like 8 weeks in law school at a public defender. So my practice is really more civil, which is kind of what I come at, although, you know, I do have some thoughts for interviewing criminal clients, but for the most criminal defendants, I should say. But for the most part, it's mostly civil. That's who I am. I also teach a class on this subject. So I teach it, it takes an entire semester, and I just got done doing it for the first time remotely, which was exciting. And I don't know if my students thought so, but it was okay. I do like in person better, but it was a good way to teach when folks are all over the place. So interesting, and hopefully you'll find it interesting. And my hope for today is that it's going to be more interactive, which we'll talk about in just a second. But first I wanted to ask Perry to introduce himself, and then I'm going to go around the room and have everybody else introduce themselves.
Good afternoon, everyone. My name's Perry Browder. I'm with the law firm of Simmons, Hanley, Conroy in Alton, Illinois. I represent people that have mesothelioma, which is an asbestos-related cancer. And I'm joining Sarah on the Rural Practice Initiative because I think it's a great program that's getting great representation, you know, throughout the state and our other counties. So looking forward to this program, and nice to meet everybody.
And hopefully, Perry, you may weigh in at some point too if you have some thoughts. So please feel free to do so. I'm sure you've got even more client experience than I do. So everybody's got something to bring to the table today, though, I think. But we're going to go around the room. So Keegan, if you'd like to introduce yourself.
Keegan Samolinsky. I'm at Gatson Milas in Peru, which is LaSalle County, and I'm a Northern grad of 22.
Okay, thank you. Stacy.
Okay. Hi, everyone. My name is Stacy Olin. I was a Chicagoan for quite some time. That's where I started my practice, graduated from Chicago Kent College of Law in 2019. Got married to a farmer, so relocated to Western Illinois. So I'm currently practicing primarily family law with the law firm of Brash and Everett out of their Galesburg location.
Okay, thank you. Hannah.
Hi, everyone. I'm Hannah Rogers. I'm currently working with the Brown Law Group in DeKalb, Illinois, DeKalb County. which mostly focuses on estate planning work. I also went to Northern Illinois University.
Okay, thank you. Jenna?
Hi, my name is Jenna. I went to Northern as well. I'm currently working at the Cosentino Law Firm in DeKalb. I'm actually from Bureau County, which is right by LaSalle County. But I've been working here since my 1L year, so I do primarily family law, a little bit of criminal I've touched on, and some civil litigation.
Okay, thank you. Michael? Is it Michael or Mike?
I go by Lawler.
Okay, we can do that too.
I'm Lawler. I'm at McMillan, Hennepin, and DeJody out in Macomb, and I'm a 2022 Loyola grad.
Okay, thank you. And Simone?
Hi, I'm Simone. I work for Maley, Swearingen, and Lobaz in Tazewell County, and I'm a DePaul 2022 grad.
Great, thank you all so much. I will not hold it against any of you that you're not SIU grads, as I am. I'm not sure what happened there, but it's great. I'm so excited that you guys are in this program. So please feel free to chime in if you have questions. I do have a PowerPoint we're going to look at. We're not going to be 100% wedded to that, but we're going to go through it, and I'm hopeful that we'll have some time in there to chat. I'm going to try to take some breaks in the PowerPoint so that we can chat. It is hard for me to see the chat function. So if you have a question, I will be able to see you with your hand raised. If I'm not answering you, please just try to interrupt me. It's okay. Oh, we have a new person. I will admit them. We'll let her introduce herself. I think this is one of our committee members, so we'll let her introduce herself, except I don't know where she went. Oh, there she is. Hey, Sarah, did you want to introduce yourself real quick?
Hello, Sarah Pesca. Sorry I'm running late. Just was preparing for 1:30 court, pardon me. I'm an attorney in general practice in Freeport, Illinois, and I practice mostly in the 15th Circuit. Thank you.
Thanks. So we're going to talk today about client interviewing. We're going to talk a little bit about the basics of client interviewing. And I know for some of you, hopefully at this point, you have interviewed a client. I know some of you have a little bit more experience, so you've probably interviewed more than one client. So we're going to touch on some of the basics, and some of these things may be things where you think, I'm already doing that, which is great. Some of them you might think, oh, maybe that's something I should try. So we'll do that. And then we're going to talk just a little bit more about like why we want to try to be so focused on some of these things. And then we're going to take some time to look at some of the issues you might have in client interviewing. And one of the things I'd like you to kind of be thinking about is specifically as you're in, more specific to real practice, or just because some of you are newer in your practice, what issues are you encountering with clients? Are there challenges you're facing? Of course, as always, please do not share confidential information or information that's going to identify your client. But other than that, if you're facing something where you're like, hey, I'd really like to know actually, how would I have handled this differently, or how should I handle that? This is your opportunity to do that. Because you've got kind of a range of experiences here, and other people may have experienced something similar and may have some ideas. So, or if you just had a challenge that you faced that you want to share and say, hey, this is what I did and it seemed like it really worked out well, then this is a great opportunity for that as well. Does anyone have any questions before we get started? Okay, I'm going to share my screen here. Okay. Can everyone see this? Yes. Okay, good. All right. So the client interviewing and beyond. So as I said, these are kind of the basic objectives that I just said. So we'll skip through that. So when I do client interviewing, there's a couple different viewpoints on it. More traditionally, I think clients, the way lawyers at least viewed client relations was that the lawyer was kind of the all-knowing expert. The client came in to see them, sat down, said their problem, and the lawyer kind of patted them on the hand and said, I'll take care of this. We'll talk to you in several weeks and I'll let you know what we've decided to do for you, right? So that's the more traditional approach. If you look back at like old black and white movies, sometimes if there's a lawyer, you see that. But over the past couple decades, it's kind of changed more towards a client-centered approach. And the general idea about that is that, and the reasoning for that is because clients come to you with problems, and it's really about client autonomy, right? The clients come to you with their problem, and you have the legal expertise and perhaps experience that you can bring to it from seeing other clients in similar positions. But clients are really the owners of their own problem. And the way I like to think about this is, at the end of the day, the client is the one that has to live with whatever the outcome of their case is. It's not you, right? Right. So given that, they're the ones that are more likely to be in the better position to identify and assess kind of the things, the sort of non-legal effects of and impacts on things that are outside of the legal impacts that you may be able to talk with them about. And they're the ones who are able to decide what risks are worth taking. Okay, so we know people have different levels of risk aversion. I myself, I don't like risk super much. I know other people that obviously there's lots of people that are very willing to take a big risk, and your clients are going to be in that range. They may fall in a different location than you. The other thing too is collaborating more actively with your clients can build a better relationship with them. And as we'll talk in just a minute, that can really help them to build trust with you and want to share information with you and trust the things that you're saying to them. It's just kind of a less paternalistic or paternalistic approach to dealing with clients, actually, if you want to think about it that way. So kind of goals of interviewing, before you interview, just kind of keep in mind, why is this person coming to my office? Obviously, you want to know what their legal problem is or their need, and do they have anything that's non-legal that they're worried about that might impact the situation? Obviously, you want to find out what the facts are, what happened, and of course, as a lawyer, you're thinking, do I have a case here? Is this something that I can do something with? If it's a litigation type case, is it something I can help them with? And then building rapport and trust with them. So those are kind of all the different things you should be thinking about before you meet with this person. So some skills. So obviously, this seems very obvious. You should, listening is an important skill. And I say listening is a skill, meaning that it's something that some people are probably innately more, more talented at, but everyone can build on this particular skill. And I find myself even, I have different levels or different times where I have a better ability to listen than others. There's so many distractions these days with phones and just everything else that we have that's distracting us that sometimes we have to kind of get a step away from that stuff to be better listeners. But it is something that if people have told you you're not a good listener, it is actually a skill that you can improve. It's not a done deal that you are just not a good listener. So what kind of things prevent us from listening well? I think one thing that especially newer lawyers really face is worrying about their performance. I'm in with this client, they have a problem. I don't actually know all the answers. I'm kind of worried about that. How am I going to do? What if they ask me a question I don't know? So you're thinking about that stuff. Also, if you have any personal things going on, those could be in the back of your mind. Things that the client is doing that are distracting. It might be, maybe they're clicking their pen constantly, or there's just something about them that is distracting you. The way that they're behaving. And then concerns about time, money, billable hours. I personally, over many years, have developed kind of a timer in the back of my head that tells me when it's just about an hour. And when the interview starts taking longer than that, my little timer is like, okay, time to move on. So, things like that can be important when you're to be aware of. Couple different ways that we listen. Okay, passive listening is basically where you're not interrupting. You're saying you're not really conveying that you're empathizing with them. Sometimes if you're not careful, if you say okay or things like that, you can seem like you're agreeing when you don't really mean to. But this would be silence. Someone's telling you something and you just are quiet, which is hard for some of us. Minimally encouraging, oh, tell me more about that. Your body language, you're leaning forward a little bit, you're looking at them, you're not, looking at your computer screen. All those things are a form of listening, but it's more passive. Active listening, on the other hand, is a lot more active, obviously, hence the name. In that situation, it's more where you're actually picking up what they're saying and sending it back to them in reflective ways. So it sounds like that was really frustrating for you. That might be reflecting an emotion. So if I'm understanding you correctly, you woke up, you got in your car, you were driving down the road, another car approached you and hit you, etc. Right? That's where you're reflecting back the facts that you believe you heard. So that's going to demonstrate to them that you understand both the content of what they're saying and also kind of how they felt about it, if that's important, which a lot of times it is. It's not judgmental. It sounds like you weren't really driving very well that day, is not empathetic, active listening. It's also not parroting back. So if someone says, that guy made me really angry, if you say back, it sounds like you're really angry, that would be parroting, not paraphrasing. And I think you might get an odd reaction from your client. The main thing about active and passive listening, though, is, you have to actually be listening. Okay, so no amount of faking, listening noises or staring at someone is going to work for you if you're not actually listening to the client. And most of the time people can recognize when you are not actually focused on them. So try to create an environment where you can actually be focused on them and hearing what they're actually saying. And then, I think it's very important for people to feel like they're being heard. So you can actually do a lot to build rapport with your client if they come in and you're the first person who's actually heard what they're saying, and you're reflecting that back in a way that they, as I said, they feel heard. That's a really important thing for folks, for everyone. So some of this I just said. Emotions, sometimes as lawyers, we think we're not therapists. Why do we have to deal with emotions? Some of us are more comfortable with this than others. Some areas of law are more, you will find this a lot more likely, like in family law, for example, obviously, but also probates, people are very upset. They've lost a loved one. Personal injury work. If you represent plaintiffs, a lot of the times they are very upset because their lifestyle has been damaged. They have been injured. They're scared about what's going to happen with them. Emotions can be really important to that case. So either helpful or an obstacle, and understanding them, understanding why my client is having trouble being able to move forward and do the things I need them to do. Oh, it's because they have this emotional block. That's really important. So you can't ignore them, even if you are not super comfortable with the idea of having to recognize them. It's not really your job to analyze, though. You're not a therapist. So it's really more to acknowledge them. So as I said before, someone's getting really steamed up when they're telling you about something, hey, it sounds like that really made you angry. It sounds like that really frustrated you. Be careful about saying frustrated a million times, because that, at some point they may say, actually, I wasn't frustrated. I was super pissed off. Right. So, but the same, even if they have to correct you, at least you are trying to understand how they felt. And sometimes just having that recognized, I think maybe we've all been in this situation where we're really upset about something. And sometimes we just need somebody to kind of put a name on what we're feeling. And that can be really helpful. And then also your client, if they are able to express that emotion with you, that may help to reduce their stress and help them to really focus on the case and the things that you really need them to do as a lawyer to get things done in the case. So paraphrasing is a tool you can use, if I got that right, in other words, would you say this, and then checking, am I right about this? It seems like you felt this way, or it seems like this happened and this is how you were saying it. Just kind of checking in. When you paraphrase, be sure not to paraphrase it in such a way that helps your case, though. So if it's something that they haven't actually said, but it'd be a really great element to meet, you don't want to paraphrase it in such a way that suggests to them something that they have not actually said. Another basic, forms of questions. And I know that I sent you materials about this, and I'm sure you all read it. So just really briefly, starting off a discussion with an open-ended question is a really good idea, because it asks them to answer in their own way with their own words, which actually helps to prevent that where you have suggested something to them that isn't what really happened. And it also allows them to tell the story in their own way, which may or may not be linear. But it helps them to kind of remember things as they happened. If you interrupt a lot with closed, narrow questions, you get them off that train of thought. And you can think about this if you've been telling a story to a friend or something. You can think about, you're trying to tell your story and they're interrupting you with a question, and then you're like, okay, where was I? And you're trying to get back on track. So allowing them to at least once tell their story without interruption, or with minimal interruption of just, minimal encouragers and things like that, can really help them to say things in their own way and remember things more clearly. Narrow questions then you can use to get more specific information to kind of refine that. You can go back and clarify what they said if you weren't sure. Think of a car accident. They're trying to tell you where it happened. You're not really sure. I just want to make sure I understand what these cross streets were. You can do that. Closed questions and leading questions are both minimally used in initial interviews, because you're not, that's more interrogative, number one, which doesn't really build rapport. And number two, it can actually end up suggesting answers like, you shot him because he threatened to kill you, right? Which obviously is suggesting a defense for someone that they may or may not have said. So starting with open-ended and then using closed to define what you're learning is a good approach. And then kind of thinking about, why do people share? So I want to pop out of here for just a second and ask you guys, so when we're talking about motivation, people are usually motivated to do things that benefit them. Okay. So, it's terrible to say, but it's true. So sometimes you'll find a client that you're trying to get them to work with you, and for some reason they are not answering your questions, they're not sharing information. Who could think of some reasons why that might be? They've come to you with a problem and they just met you. Think about it in your own words. I'm just going to call on someone if no one says anything. I'm just warning you right now. So if you have any thoughts, you might want to reach out and raise your hand or just start talking at this point. All right, Hannah.
Sometimes they might be a little bit embarrassed about what they did or exactly what they said, so they don't want to share things that reflect poorly on them.
Yeah, exactly. I mean, you think about it, how weird is it, right? You had this thing that has happened to you, and you're going to go to a total stranger and start telling them all about it. So yeah, they might be embarrassed. Their ego might be at play. Maybe they made a bad deal. Any other suggestions or thoughts about why they might not want to share with you fully? Yes, Mike Lawler.
I think, especially because I was in public interest before I moved, trust is a really big deal. And especially if this is the first time they've met you, or if it's a phone interview, you're just a total stranger to them.
Yeah, you haven't built any rapport with them and they have no idea who you are. They don't trust you. Okay, let's try one more suggestion, then I'll go through my list with you guys. One other thought. Perry, how about you? Have you ever had clients that weren't fully sharing with you?
Absolutely. I think sometimes not only are they embarrassed, but they know they may be a part of the problem. They're not going to open up and be honest with you. And that's a big thing because they'll always tell you what the other party did wrong, whether it's criminal or a family law matter, or even in an injury case. But when you're trying to get them to open up about, any weaknesses in their case or things that they may have done to contribute to the problem, they're not going to always be that open with you. And sometimes it's hard when you want to get to those things. They may start feeling like you don't believe what they're telling you. So that there's a fine line of wanting to believe your client and support them, but also finding out what the weaknesses are that may come up to, as you go forward in the case.
Yeah, and they may be afraid. They want you to represent them, and as long if you're not a public defender or somebody like that, you can say no. So if they believe that they've done something and there's something about their case that may be bad, that may make it not a good case, they might not want to share that with you, which very important that they do share, right? Because you want to learn that information in that initial interview or as close to it as possible, not when they're testifying on the stand. That is the worst time to learn that information, which I can attest to. So let's go back here to the PowerPoint slide. And let's see how we did. I think there's a couple other ones. Oops, if I can get it to, there we go. All right, so we call these inhibitors, right? Things that inhibit people from talking with you. So self-esteem, embarrassment, fear that harm might, we've got the top two. Fear that information might harm their case. Other things, you're the expert and they expect you to control the dialogue. So if you didn't ask them something, it might not be important. Okay, they might not recognize it as important. They might be more comfortable talking with a peer. So let's say they're an older gentleman and they're just not comfortable talking with a young female about something, just as an example. Recalling an incident might raise unpleasant feelings or cause trauma. So if you think about family law, you deal with domestic violence situations, all kinds of stuff, and talking about it might be very upsetting and difficult for them. They might just not think the information is relevant, and they might need to talk about something else first. And this happens a lot where if you find someone really going on and on about some other item that isn't what you really want to talk about, sometimes just letting them talk about that item first gets it out, and then you can move on to the thing you want to move on to. So some other things that you can do to overcome things that might be preventing them. Being empathetic and non-judgmental, obviously, because if they perceive you as judgmental, they're certainly not going to want to share the embarrassing thing they did. Telling them that you expect that they'll tell you everything, which I think is really important to reiterate with clients sometimes, that, and just kind of the consequences of not having all that information up front and how that could really damage their case if you find it out later. Thanking them for helping, that was really useful what you told me. Suggesting them, the altruistic appeal that, if they fully help you with their case, it might help someone else not have the same thing happen to them, which does actually happen. There are clients that care about that. Telling them that they're more likely to get a more satisfying outcome if they tell you everything now. recognizing and acknowledging those emotions, and then normalizing, which is basically saying, you know, something along the lines of, you know, I've done a lot of these cases and here's something that I've seen people experience before. You know, is that something that you're experiencing? You know, or something like that to help them realize that they're not the only ones that have gone through this situation. Don't make that up. I mean, it has to be something that you really have seen frequently. Okay, the interview itself, some of this stuff is basic, and you're going to do it differently in different firms, but obviously you always want to do a conflict check. You always want to figure out what the nature of the problem or the area of law is. Is it something you're competent to do, or you could get competent, or someone you can work within your firm is competent? Is there a deadline or other reason to expedite it? Reviewing any documents they provide if need be in the law, if need be, might be something you need to do. Considering the location or if they need any accommodations. So for example, in my office, we have stairs, we have an elevator, we have downstairs conference rooms, you know, so maybe sometimes someone has a walker, they have a wheelchair, and we have to find a location that would work best for them. Greeting the potential client when you first meet them, obviously greet them. Sometimes a little icebreaker is a good idea, depends on the situation. If they're wearing a Green Bay Packers shirt and you're a Packers fan, maybe that would be a good icebreaker. You know, something like that, if that's something you're comfortable with. But something to help make them feel a little bit at ease. And then explaining in the note taking, you're going to take notes, and the confidentiality aspects of it, that also explaining confidentiality and then reminding them of that can help them feel comfortable sharing with you. And then Zoom, I just want to add this on here because I don't know if people are doing Zoom interviews. I know I do sometimes now, especially after the pandemic. Just kind of keeping in mind with that, the privacy aspects, making sure that when you're talking to that person, they are in a private setting, because the last thing you want to do is have them in a spot where someone that they would not want to have overhear can overhear. So check in with them, you know, are they sitting at the local McDonald's doing Zoom on their phone with you while you're talking about confidential information? Maybe now's not the time to do that. Okay, maybe try to, and maybe if when you make the appointment, kind of checking in with them to make sure they're going to be in a good location. That's just kind of a newer thing with video conferencing. Phone calls, obviously, same problem. But video, you know, anyone can hear you. So kind of as a basic outline for your interview, you want to start out trying to get a concise statement of the problem. I usually start out with, you know, why don't you tell me what brings you here today? Even if they've already told my assistant or me, you know, I might acknowledge that, you know, but I need to hear more of it from them. And then kind of, do they have any ideas for how it might be resolved? In this case, this tends to be a lot more efficient than starting off with, you know, having an idea of what their problem is and trying to latch on to that one problem and only ask questions about that. And also it can prevent you from missing other possible causes of action because you thought it was just one thing, and it actually, maybe there's something else out there that you discover when they tell their story. So figure out why they're there. I like to give them a roadmap for the interview just so they know kind of what's going to happen next. You know, make sure that I kind of summarize what I think they're here for, so I make sure I'm on the right track. And then, you know, I usually will be asking for kind of a chronology of events if it's a litigation case. If it's something transactional, like estate planning or something like that, you know, I'm probably just going to give them a heads up. You know, I need to ask you some personal questions about your assets and things like that. This is why. I'm going to remind you about confidentiality, just so they're prepared for that and they're more comfortable. And they may have gotten some idea that I might be asking those before the interview even starts. You know, you can interrupt them if need be to ask clarifying questions, and you might want to let them know that we might not get everything done today. Sometimes it takes more than one interview. Timelines, I like to get a good timeline of events, and then that timeline actually, if you're going to have litigation case, can actually be utilized throughout the case as you're trying to keep track of what happened. Maybe it's a complex situation where you have to add things, add dates, add events as you go along, and then by the time you get to trial, you can utilize that you started in the beginning, maybe even if need be as an exhibit or something. So it can be really useful. And also if other people in your firm are working on it, they can easily get up to speed by looking at that. So it helps you understand what happened, clarifying inferences and clumped events. So basically inferences, you know, if someone says, I got in the car, I drove down the road, I ran into a telephone pole, and I went into a bar and had a couple beers, that is different inferences are drawn from that than from, I was driving down the road, I stopped at a bar, I had a couple beers, and then I ran into a telephone pole, right? So we need to know kind of what happened when, because it can be important as to what inferences we might draw from that situation. Clumped events are kind of when people say, Like if a realtor, you say, my realtor and I went through the house before I bought it, what does went through meant? You know, I mean, they looked at specific things. So that's kind of parsing out what are those things they looked at. It also can help your memory sometimes to walk through things. So I had one of my rare personal injury cases was a motor vehicle case where the client couldn't remember what actually happened. And it was really helpful to actually just walk her back. You know, you got in your car, what happened next? You know, okay, this happened, what happened next? And just walked her through in a chronological way. And then it can help you later when you're trying to figure out theory development, which are questions that are going to help you understand whether you have the facts to support your case. But basically, like, you allow the client to kind of say what what happened when, which is really important. Using mostly open-ended questions, and then you can use what's called the T-funneling approach, where basically you start with an opening question about whatever, open-ended question about whatever topic it is, and then ask specific questions to kind of narrow it down until you've completely run out that topic, and then go back and ask other questions about another open-ended question about another topic that's important. You can also look for omitted events. So if there's kind of a gap in the timeline, what happened in between here, something really important may have happened. Always remembering that, as Perry said, this is your client's version of events. So I don't like to say story. I mean, I did say that earlier, but when I'm talking with the client, I don't like to say story, but it is their viewpoint. It is what they see as having happened. So the other side may have seen something differently, and later on, you're going to find that out. Or you may already know if they sued you. And you might also find that there's people that are missing. So if it's a corporation, let's say it's a negligent, or some kind of situation involving the termination of an employee, you may need to talk to more than just the person that you're talking to. You might have to look at documents. So then the next step would be trying to ask those factual questions that usually as lawyers we're actually pretty good at. So if I know it's a breach of contract case, I need, I think that I need to ask questions to see if there's facts that support that, the elements of that. I'm not going to embarrass myself by trying to say what those elements are. I'm just going to move on, but you all know what they are. Or a negligence case or whatever, is there factual evidence to support what it is that you need to prove? Is there any evidence that bolsters your client's credibility? Are there things that are weaknesses? Those are all important things you're going to try to glean now and in this early interviewing process. And then things that the other side might have that are positive or negative for them. So again, you can ask questions directly. You can also use that T-funneling approach. Sometimes clients, you want to talk about this one topic and your client kind of goes off on a tangent, but they might raise something that actually you do want to follow up on. What I like to do is acknowledge that topic and then park it, let them know we'll come back to it. Because I find sometimes if I follow that topic, I will forget to finish up the one that I was working on. But there's different approaches to that, but making sure that you come back to that topic if they raise it and you don't talk with them about it. Asking clients about their bases for conclusions. A lot of times clients make assumptions. So, like, for example, that the other side would never settle this, that may or may not be true. So you want to kind of ask them, why did they think that? And find out, whether that's based on anything or based on just their assumption about the other person or situation. Probing gaps for additional events. Bookending, as I said, did anything happen between the two events? Basically, as I said, anything that's going to help to rebut the other side's case and help your case. Then at the end, this is kind of important. It is really important. At the end of this interview, whether it's just one interview or whether you've had to have a couple to establish all this initial information, you want to make sure you know what's going to happen next. Okay, so whether you know what you're going to do, you know what they're going to do. Okay, so if at the end of the case you may take the case, or you may need to get more information before you can take the case. If you're new you're an associate, you may have to ask a partner if you can take a case. You might not be able to do that. So you might have to let them know, I need to check with my partners on this one. Or you may just know right off the bat, I am definitely not taking this case. So these are the kind of the different options, and you need to kind of know at the end of the interview which one is going to happen. Or the client may say, I'm sorry, I really don't want you to help me, which they have every right to do. So unless you're not hired or you decline it, your conclusion needs to tell them who's going to do what and when next. I'm gonna research this. I'm gonna get back to you in X number of days or whatever. Be realistic. Don't tell your client, I'm gonna get back to you the day after tomorrow, and you have to do all this research, and then you're calling them saying, or you just don't get back to them. Don't do that. Like, be realistic. If it's gonna take you a week, tell them it's gonna take a week. If the client needs to do something, you need more information, you don't want them to do something. I think, anyone who's done family law, perhaps you want to tell them, please do not go post a bunch of things on your Facebook page about your person that you're upset with. At this point, you may discuss fees. You probably should discuss fees if you're going to take the case, or at least they're going to consider retaining you. They need to understand what they're going to pay for it, if they're going to pay. Explaining what the next steps might be. If you don't take the case, be really clear that you're not taking the case. Okay, we are not going to be able to help you. We are not going to be doing anything on your case. And follow that up with a non-engagement letter. Your firm may have a form, ISBA Mutual Insurance, which I gave you guys some information from them. They have form letters. If your firm uses a different insurance company, they probably have form letters. Follow up with that non-engagement letter so that there's never a question later as to whether or not you were going to help them or not. Because if there is a question and they could reasonably have thought that you were helping them, the ARDC is going to say that that they're going to align themselves with the client, not with you. Make sure you check out Rule 1.16 of the Illinois Rules of Professional Conduct, which is about declining or terminating the representation. And we're not going to talk about terminating the representation at the moment, but there are some specific rules about when you can do that and at what point in the case. So you want to make sure you know that. Okay, so we're going to take a little break here, but we have a few other things to talk about, but I really want to hear from you guys. So at this point, are there any questions you guys have or any specific challenges with clients that you faced where you kind of wondered at that time, how should I deal with this? Or anything specific? I don't know if anyone has anything they want to add to what we've talked about so far.
I do, just in some experience that I've had. I know, in case it's helpful, I'm obviously a 2019 grad, so I've been practicing for at least a little bit longer than, some of the 22 grads. So something that I've certainly run into a few times is 100%, if you haven't heard the term CYA, it's super important, especially when interviewing people, so that there's absolutely zero question in your mind as well as the client's mind when that attorney-client relationship is formed. So to supplement what was already discussed in the lovely PowerPoint that we saw, I ran into this sort of limbo period where, I'll be ending the interview and talk about, rates, retainers, what have you. And the client will let me know that they need some time to either think about it or, gather whatever funds to pay my retainer, something like that. And so I'll send, either a fee agreement for them to just take a look at, see if they have any questions, but I take that extra step to make sure that they understand exactly when that attorney-client relationship is formed. And sometimes I almost feel like I'm beating a dead horse, if you'll forgive the phrase. But I do think that that's so important because I've had a potential client come in where I interviewed them. I told them what my rates are. I told them what the retainer was. They're like, okay, we'll get back to you. And then they come back thinking that, or asking what's been done on their case, and apparently didn't fully understand that I don't represent them at that point. I've also had a situation where a client called after interviewing them and I knew I wasn't going to take on the case. They were like, well, they, went on with their life, got into some trouble and called me asking to, represent them at this upcoming OP hearing. And I had to, re-explain that I don't, represent them, as I explained during our interview. The attorney-client relationship isn't formed until that fee agreement is signed and retainer paid per the terms of the fee agreement. But I think just really being super careful, documenting, whatever that, how you left it with that client is so, so, so important. So that's just my 2 cents. I really try to explain the exact moment that attorney-client relationship is formed, because otherwise, like I said, it can get a little dicey.
Yeah, and I would add to that, one thing that also sometimes happens is if you have a potential client that calls and then they want to think about it, they're going to get back to you, and so you haven't done anything but just have a conversation with them. I like to keep them, like keep a timer, like a week or something like that, and I will follow up with them. And if I don't hear from them, I will actually send a letter saying, depending, like if it was just like, really minimal, but if it was something where we had any discussion, I will actually send a follow-up letter. Hey, if I don't hear from you within X number of days, I will assume that you do not need our assistance, so there's something that shows we're not helping that person. So, that's a thing you can do. The other thing I would add to that too is within your own files, make sure you take really good notes, because we have had situations where a firm, an attorney has left our firm, and then I've had to take on that case, and you're looking at the file trying to figure out what the heck's going on. And there's terrible notes that are just very minimal that meant something to them, but they don't mean anything to you. And I have no idea what's happening. So, keep that in mind too, so someone else can understand what's happening with the case. That's more client, I guess, file management, but make sure you do that. Any other questions or things that people have run into with clients that they have, have thoughts on or they've struggled with?
I was going to add, when you're representing older clients, get a sense of the family dynamic, because sometimes there's going to be children involved and you don't know what they're going to say or what they're going to add. And for example, one time we signed up a family and I started working on the case, and I found out the son's an attorney, and they didn't bother to tell the son that they even filed a lawsuit. So you talk about an awkward moment, because the attorney was a personal injury attorney, and they didn't even bother to tell their son, who was in that type of practice, that they were going to proceed having a lawsuit. Now later on, it was fine when we were able to get a sense of that family dynamic, and the parents just thought, well, it wasn't a big deal, and that wasn't their son's area of specialty, so they didn't think they were slighting the son. They just thought they were taking charge and getting things done. But if you get a better sense of what the family dynamic is with any children that may be involved, whether it's an estate issue or it's a business issue or a personal injury issue, you kind of want to know that at the interview. Is there something else out there, just so you're prepared and you can follow up on it.
Let me ask, well, first of all, is there anybody else that wants to raise a specific concern? I guess, has everyone met with clients? I guess I'm kind of assuming. Has everyone had a chance to do that, I hope, at this point? Okay, I know you guys haven't been doing this a real long time, but is there anyone else that has a question or something that they've encountered that they want to chat about with everyone? I will say one question that I get a lot is about, at least from students, is that, how do I talk with clients about fees? It feels very awkward. Has anyone had that situation, or does everyone feel real comfortable explaining what it's going to cost to people? You guys are all good with it. So I personally have struggled with this, and I think I've heard this too, is about how to explain fees to the clients. Because to me, it seems like sometimes the fees seem very, very, very high, especially when you're trying to help someone, and it feels somewhat awkward to then tell them it's going to cost a lot of money for them to get the help that they need. So I personally do try to save that for the end of that initial interview, because I think it's really important to let them know up front what it's going to cost. I don't want them later on to come back and be all excited about me helping them with their case, then they can't afford it. The other thing too is that when you have that discussion, it allows them to decide, whether they can afford your services, but you also sometimes can get a sense about that as well, or whether you maybe need to give them a different resource, because I will tend to give them if I feel that if they express that there's a low income type situation, I will give them a different reference, like a Land of Lincoln or something like that.
Well, and Sarah, I think you brought up a good point. When you're discussing fees, you do need to be direct, and sometimes you'll have a client who the fees are being paid by the parents, not just a child in a criminal setting, but we're talking about adults where their parents are paying for their divorce. And you got to keep in mind, what are you getting consent to share information on?
Yeah.
And what are you not getting consent to share information on? Because the parents may feel, hey, I'm entitled to know because I'm paying your bill, but your client's the client.
Yeah. Child clients also, I've represented minors, and that's just, we could do an entire CLE on minor clients, which we aren't going to do, but that's a whole nother issue, is what rights do they have and that kind of thing. So, and the other thing is retainers. Make sure you're really clear about how that retainer is going to work, because I think sometimes people have the image of, I have my lawyer on a retainer, which is a very different kind of concept than what we're usually talking about. So they need to understand it's going to be X number of dollars. It's going to go in our trust fund. It's not actually going to apply to your bill until we've earned it. Maybe you do replenishing retainer, make sure you explain that, whatever the situation might be, make sure they understand how that's going to work, so that they know. And also so they know, when you say it's a $2,000 retainer, you're not saying, and that's all it's going to cost. Be realistic with them as to what it's going to cost if you can, or be reasonable with them and let them know, there's no way we can possibly estimate exactly what this is going to cost, so they know that. All right, so one thing I want to really touch upon is some red flags. So we're going to go back here for just a second. Oops. Special problems. Okay, first of all, strong emotions. Okay, this is something that you will encounter in all kinds of cases, really. I mean, family law, obviously, that's a lot. So you may encounter that in rambling, client lying to you, client asking you to do something wrong. Always remember that you are not a hired gun for this client. So your law license, you spent a lot of time trying to get that. You've worked really hard for that. So while your job is definitely to zealously advocate for your client, it is not your job to do things that are unethical or criminal or fraudulent just because your client asks you to. Please be sure to check out clients with a diminished capacity. This comes up a lot in estate planning. It comes up in lots of other kinds of cases too, though, and it may not just be mental impairment from elderly. You could have someone with a mental health issue, substance issue, or a minor child is legally determined to be have a diminished capacity. And I don't know if kids would agree with that, but they are legally not competent to make decisions. And basically what that rule says is the lawyer shall, as far as reasonably possible, maintain a normal client-lawyer relationship with the client, which sounds really easy, sounds so straightforward, but really it's not that straightforward. It's kind of complex. Make sure you read the comments to that as well. Once again, rule 1.14 could also be an entire hour-long CLE in and of itself, but make sure you're familiar with that. Make sure you're familiar with all the rules, but that one is a very important one. Couple tips. We've talked about building rapport and trust with your client. You know, try to understand them, treat them as people, which doesn't mean asking a ton of super invasive questions, but certainly getting to know them a little. You know, I just recently learned that one of my clients who was 95 passed away. I hadn't seen her in a little while, but when I was working with her, you know, I learned a little bit about her history. She had danced for the USO during World War II and shared that story with me, and that really had nothing to do with her estate planning, but it really helped me to get to know her better, helped her to build rapport with me. Communication is key. So I just have 2019 stats here. I'm sure it's pretty much the same though. 20% of complaints to the ARDC, which is the Attorney Registration and Disciplinary Commission, hopefully everyone knows that, are based on failure to communicate. Sometimes it's really tempting if nothing is happening, or if you feel frustrated with what's happening, or your client is annoying you because they're calling you all the time, to just ignore them. And that's actually not a good strategy, because for one thing, it could result in a complaint, but also sometimes if you just chat with them and let them know, hey, we're still waiting on the judge to make a decision or whatever, they know, you know, because remember, for you, this is one of who knows how many cases. For your client, this is their only case. This is the biggest, most important thing that's happening to them in a lot of cases. It's super stressful. And when they don't hear from you for a couple months, they think that you're not doing anything. They don't think that, oh, the judge isn't doing anything, which is often what's happening, or the other side isn't doing anything, or just nothing's happening. So communicate with them. Get your assistant to call them back if you have an assistant, if you're not able to do so right away, but have someone communicate with them. Using non-engagement letters, engagement letters, and closing letters, as we just talked about, CYA, very important. Understanding and managing their expectations. I think this is really important at those initial stages, to make sure that they understand, you know, that there are risks involved in lawsuits. You know, that you don't say, this is $1 million case, you know, and then you get down and all these things go wrong. And now you're trying to explain to them why actually they're not going to win, or maybe they're only going to get $5,000 or whatever. You know, you want to make sure you manage those expectations, and also manage their expectations about your time. Okay. If you start answering their emails at 10 p.m. at night, your client is going to believe that you will answer their emails at 10 p.m. at night. So if that's okay with you, that's fine. If you don't answer emails at 10:50, you don't want to deal with your client's stuff at 10 p.m. at night, don't get into that habit, and be expressed with them about, you know, this is when my office hours are, or whatever. Be clear with them, you know. And I'm not saying what that is whatever it is for you and your firm, but make sure that they are aware of it, because otherwise you could end up with your whole life dealing with this client and their problems, when it's, you know, to an unreasonable degree. Understand their goals, of course. Make sure that you're not thinking about what you would do in their situation, but what is best for them and what they want to accomplish. Okay, this is the last little thing here, although it's probably the most important, but we have 10 minutes left and I really want to go over it. Are there any clients that you should not accept? Yes, there are. There are some red flags. We're going to talk about those red flags here. Potential red flags. So before I share my potential red flags, let's just have everyone else share. So are there any red flags that you guys could think of? You met with this client. What is a red flag? Hannah?
If they've been fired by their lawyers before, or if this is the third or fourth lawyer they've worked with on the same issue.
Yes, many lawyers in the past, please, is very tempting when they're like, I know you're the best lawyer. I've had all these terrible lawyers, but you're going to be the best. Maybe, or maybe they just are really hard on lawyers. And you know, sometimes I have had people come to me and they've been like, I have this terrible lawyer. And then I'm able to tell from looking at the name of the lawyer that it's possible that is true. But other times, especially if you look at it and it's like, well, they've had 3 or 4 lawyers and these are people that are pretty good. That's probably not a good sign. All right, so that could be a red flag. What are some other possible red flags? Simone?
They've waited until like 2 days before their court date to reach out to an attorney.
Yes, so this is why you want to ask about those deadlines. Now make sure you check their assumption to see why they think there's a deadline. I did have a client at one point that had a huge, super complicated employment contract, and he wanted me to look at it and review it and give him all the feedback in like 2 days. And it was not possible for lots of reasons. And I went and talked with them, and it was just, he was the vice president of a big corporation and he just wanted it done in 2 days. And after we talked about it, he was fine with more time. So make sure that their deadline is actually a real thing. But yes, if someone comes to you and they're like, oh, the statute of limitations runs tomorrow, you know, or I have a hearing in 2 days about this thing, you know, you are completely unprepared for, that's a red flag, and you should really be realistic, because that can really get you in trouble. And they also may not be very prompt about getting you things in the case and stuff like that if they're procrastinating that bad. What are some other red flags? Lawler?
The one I've run into most is expectations of people wanting to, especially when I was back in Chicago, wanting to sue the city and like get the mayor imprisoned. Like that's not going to happen from just a pro bono firm.
Yeah, so they may have very unreasonable expectations. Now, sometimes you talk with people and you can get them to be more reasonable. But other times it's like, this person's never going to be reasonable. And if they're not, if they're super unreasonable or super high maintenance at the very beginning, they are probably going to be like that the whole time. Usually that's the case. Not always, but usually. What are some other red flags? Perry, any that you've encountered?
I have 2. One is builds on what Lawler just said. When the client's shopping it around and says, oh, you know, another attorney's telling me this is worth $2 million, they're shopping it around, they're not going to be happy. And if that's the case, you say, fine, you know, tell that other attorney to put it in your contract that it's worth $2 million, because that other attorney won't do it. And the other one is when they outright lie to you. We've had clients say, oh, it's myself and my daughter. And it turns out there's a brother out there that nobody wants to have involved. When they lie to you right off the bat, it's only going to get worse over time. So when you catch them in a lie, you got to really be skeptical as to everything else that they're telling you, whether it's truthful or not.
Yeah, and to follow up on that, that's why I think it's important to take, you know, and I know we all have varying degrees of how much time we're able to take with clients. I know someone that used to be a public defender who really had an extremely limited amount of time. But if you have the ability to take a little bit more time in the initial conversations with the client or potential client, do so, because usually when people can hold on to something, unreasonableness, lie, other stuff that you don't want to deal with for a certain period of time, and then it starts to come out. So, you know, if you chat with them long enough and get in, you know, enough of those open-ended questions, you're going to hopefully start catching when they're saying things that are not truthful. Stacy, did you have one that you wanted to add?
Just another quick red flag. It kind of touches on expectations, but I've had, you know, clients suggest that their expectation is that I do something that is unethical or would, you know, question my own personal comfort level or integrity. So that's always a red flag.
Yeah, you have to be careful about that. What about you, Sarah, from your practice?
I was thinking just someone reluctant to pay maybe a retainer, or clearly very uncomfortable with a billing schematic, whether it's the hourly or how it's done, or an expectation to replenish a retainer. Those are huge red flags at the beginning. And at the end of the day, we are mostly all in business as well. So at least in private practice, I see that.
Yeah, and I personally have made the mistake of being like, oh, I really want to help this person, and I try to adjust it, and and sometimes that works out okay, but a lot of times it does not. And if they can't pay, if your retainer is what it is and they can't pay it up front, they probably aren't going to be able to pay the bill when they get it. That's the problem. And and honestly, on some level, it's not helpful for them to get a certain percentage of the way into the case, and then you have to withdraw from representing them because they can't pay you. So, it also isn't great for them. It's definitely not great for you. It definitely doesn't make your partners very happy when you're like, oh, sorry, I didn't get paid up front and they just filed bankruptcy and now I'm not getting paid at all. Sorry, which has happened to me. So I know. So one thing I will tell you, and I think it's really important, just kind of as an aside, I feel this way. I think Perry, Sarah, probably the same. And maybe Stacy too, just, early in your career, but a lot of the stuff we're saying is because we have encountered these things, and we have also, I have made mistakes and learned from them. So you will make mistakes, everybody does, and you'll learn from them. And hopefully they'll be ones though that you can try to avoid or minimize the really severe mistakes, obviously. But so I will tell you, one of my red flags is super highly emotionally unreasonable people. But I also am one of the only people in my firm who's really I am really good at dealing with really emotional, unreasonable people. So I tend to overestimate my ability to do that. And I have had cases where I'm like, wow, this person she's really histrionic about everything, but the case is really interesting. So I got sucked into one at one point because the case that factually was very interesting. And I felt like I could really, we're going to win this, it's going to be great. But there was like this little, like on the back of my brain going, this person is very annoying and very unreasonable. And so then what was happening that made it worse was the person started calling me all the time. Like, call me one day, I didn't get back to him right away, like within 2 hours, calling me again, calling me the next day, like, and then the final straw in that particular case was the person started saying, well, you told me this, and it was completely not in any way what I told them, not any way what I would have told them, and getting really like kind of directing that back at me when things didn't work out. So those are all things I could have avoided if I listened to the little voice in the back of my head that said, this person is going to be really bad, you're not going to want to do this. And I actually ended up having to fire that person. That's the only situation where I've actually had to fire a client, I have to say. So I've been fired, which also happens. It'll happen to everyone. But that was the only one where I just at some point was like, this is not going to work. So let's just real quick, we have time. Yes, we have 2 minutes. Let's just look at really quick at our little list here and see if there's anything we missed. All right. Oops. All right, many prior lawyers or case was mishandled. Yes, we talked about that. Oh, it's your coworker's friend or relative or your coworker. Yes, representing your friend, your family member, your relative, or your coworker is a very big red flag. I guess it's a big headache. I don't personally think it's a great idea, but just keep that in mind as something that could possibly go wrong at Thanksgiving when you are, with someone whose case didn't go well. Overly concerned about fees. All my prior lawyers were incompetent. I filed ARDC complaints against them. The client has already done things that have really caused significant problems for the case, okay, that you can't fix. Personal vendettas, it's the principle of the thing, or money is no object, 2 phrases that I've heard that never turn out to be true. Once the person starts getting the bill, lies to you, and as you guys said, the very tight time frame you can't reasonably miss. So yeah, money is almost always an object at some point, even when they say that upfront. Any other questions?
Sarah, one thing I was going to add to that list too is if you ever feel unsafe where the client is a threat to you personally, don't take that client on. You just never know where it's going to escalate to. And the next thing you don't need is someone that may physically attack you or stalk you. It's something we don't talk about much, but it really is out there.
Yeah, I've not had that happen personally, but that's a really good point. So yeah, that's probably listen to your gut, I think is good advice. If somebody feels like, like it's a wrong situation, don't get into it. All right, any other questions? All right, well, thank you, Sarah and Perry, for your additional insight. And guys, everyone, thank you very much for your input. It's really helpful for everyone to hear. And if anyone has any questions or that they want to share with me personally after, My email is somewhere. Is my email on anything that they received, Krista?
You're probably on the Outlook invite with them, but I can definitely make sure to do a follow-up and provide Sarah's email.
Yeah, so I can't answer any specific questions about your specific clients, but if there's something that you generally have a question about, I'm happy to chat more with you by email. Everybody, good luck. Thank you so much for being in our program. I hope you continue to have a good experience with your firms, and good luck to all of you in your future careers. And thanks everyone. Thanks, Krista.
Thank you, Sarah. Thank you, everyone. Have a great day.